Okay, now it's recording. Okay, thank you all for coming. I'm Jim Smith. I guess I introduced myself to all of you. And this is Dan McKenzie, who I mentioned in the article is going to be talking to you about estate planning for baby boomers. I understand there's a couple people here who are outside that definition of generations, but come over here. I'm going to give you this microphone. It is being recorded, video recorded, and I'll be putting it on YouTube. So if you have friends who missed the presentation today, it's zoomed in, it's way at the back, but it's zooming in, and you're going to use the whiteboard, right?
Yes.
And so if you write big enough, they'll be able to see that too. So here, let me wire you up, and away you go.
Great. All right. Thank you. Well, as Jim said, I'm Dan McKenzie. I'm an estate planning attorney in Centennial. I have been an attorney a little over 20 years now. I was a litigator for the first 10 of those years, doing large, complex federal litigation, and just really did not enjoy the constant combat. So I decided to get into estate planning and found out it's there too. So there is still combat even in estate planning, but hopefully if you do it correctly, there is not, right? That's usually a very important thing that people are bringing up to us. So I'm going to do two things here, probably just a general overview of estate planning. You might have done it before. Actually, I usually ask if you've done it before, but it's kind of a trick question because the reality is that you're always estate planning, actually. Whether you were drafting wills or not is another question. But when you're deciding how to title assets, when you're deciding who to designate beneficiaries on, when you're in the doctor's office filling out emergency contact information, all of those things are estate planning, actually. So you are doing it a lot, and it's just good sometimes to do it all at once and kind of go back and think through things. That's where people kind of fall down. So we got instructions all over the place. So I'm just going to go over what estate planning is generally first for you, and then talk about the most common asset protection question we get, which is usually asked for me by people in this demographic. So we'll go over that too. And I will be happy to take questions. I think the best way to do it, we're trying to get you out of here in an hour or less. We're right at dinner time here, so I want to be respectful of that. It's a little bit easier to control that time if we save the questions till the end. So we did give you some sheets of paper to note stuff. Take notes about what you want to ask, and I'll be happy to answer them. So the beginning of this really is just mentioning, again, people think estate planning, they hear that, they're thinking that is a will that leaves, directs where things are going to go when I pass away. And that is a part of an estate plan, but really only a part, and sometimes the will ends up doing nothing at all. And we see a lot of wills that actually make things worse if there had been nothing at all. So I'll get to that in a minute. Really, your bigger risk at any point in your life is incapacity events. And the problem with incapacity events is that it means so many different things. It can mean that you're out of town. It can mean that you have a pretty advanced case of dementia. It can mean that you're in the hospital suffering some sort of discrete event that's going to end at some time. Unlike death, when you pass away, people know you've passed away and cannot do stuff anymore. With incapacity events, there's not really an agreed upon document to make that clear or even agreed upon definition. If you've done estate planning before, you probably did powers of attorney when you were doing that, which is really important. Unlike the other estate planning documents that you typically think of, like wills and trusts, powers of attorney can go stale, meaning that the older they get, the harder they get to use. They are probably the easiest documents to draft. They're kind of the most standardized and the part where you do maybe the least decision making. But as you can imagine, if you walk into a bank or if your kids walk into a bank to do something for you and they're carrying a power of attorney that is 10 years old or older, we've seen some that are much older than that, the bank, like technically, yeah, it's still in force. If you haven't done anything to avoid it, the bank is going to be super nervous about that. So we usually tell people, even if you've done estate planning before, every few years, probably print those powers of attorney out again, sign them again, and put a fresh date on that. So I just do a little timeline here to reflect, this process. And segment 1 here is just the incapacity planning. And again, that usually refers to those powers of attorney. If you have a trust can be really helpful in that circumstance too, and I'll come back to trust in a minute. Segment 2 of the estate planning is if you have passed away, You know, everybody, when they're talking about wills, are very focused on one particular part, which is, again, who.
In processing the video, I realized there's about a 5-minute gap here, so I apologize for that.
Need that cat. They can't wait months and months for them to figure out who's entitled to it. So that can be really good. It can be not good if it's out of step with what what you actually intended, which can happen over time. I mentioned life insurance and retirement accounts. You can put a beneficiary on just about anything that has a title. So you can put them on your cars, your bank accounts, your house, pretty much, like I say, everything except maybe the stuff in your house that you can pick up and touch. You can't really put them on your furniture. But other than that, you can put beneficiaries on a lot of stuff. And again, it makes it real easy. So if you want to put a beneficiary on your house, you record what's called a beneficiary deed with your clerk and recorder's office. And that's a special deed that does not change ownership of your house while you're alive. It just tells them, if a death certificate gets recorded for me, here's who now owns the house. And again, it's done. So that can be a way to do it. I usually tell people be a little bit cautious about that. It's got two drawbacks. One is I usually am most comfortable with it when we're leaving the house to one adult. If you put multiple people on the beneficiary deed, they are all owners together. And no one's in charge. They're all equal. So when you co-own real estate with somebody, there is a lot you've got to agree on. Even with your spouse, who you chose, and the house that you chose, there's a lot that you can kind of think, well, I want to decorate this room, and I don't want to, I want to sell this place or rent it out or whatever else. Lots of stuff to fight about. When you get thrown into that relationship with a sibling that you may or may not like, that can be real tough. So you just want to be really careful about that. And then number two, beneficiaries only kick in after you've passed away. So like I said earlier, your bigger risk at any point actually is the incapacity, and designated beneficiaries are not of any assistance in that phase. So you just want to be aware of that. Number three is you can plop stuff into a trust. I'll come back to that in a minute, but a trust is basically just an entity that you're creating to hold your stuff for you, and you run it, usually while you're alive, and the benefit of the trust is somebody else can step in and run it when you can't. And so it's got a lot of benefits that I'll cover in a minute. And then 4 is your will. You might have thought I wasn't even including the will on this list. But people think the will is the most important document. It's way down here at number 4. And then number 5 is state law is going to say where things go if you've gotten past all these steps and still have things unaccounted for. So it's usually helpful to know in a traditional nuclear family where we've got parents who have been married to each other their entire lives, their kids are together. State law does what most people want. It's like, leave it to the spouse. If my spouse survives me, once we're both gone, split it equally between these kids. It quickly gets a lot more complicated in blended family situations where you've got stepkids. So the problem that you have when you have stepkids or step relationships is that they're not really recognized in estate planning. If you like I said up here, you can leave your stuff to anybody you want to. You can cut out kids, you can add other people, you can distribute it unequally, you just got to include your spouse. But other than that, you can do whatever you want. But you got to say it. And with stepkids, they are nothing. They have no right to your stuff. And so we get a whole mix there. Sometimes people come in and say, well, my stepkids, I've been raising them since they were babies. They call me dad, and I consider them my kids. In other situations, of course, it's like, no, we got married when they were in their 30s. I've never lived with them. We see them twice a year. I would leave my stuff to my kids. So you just got to be really thoughtful about that situation. Very common, obviously. This list is in order of how we go through things when someone passes away. And so when someone passes away, we go find everything that they have any ownership interest in. We pile it on the table, and we run it through this list to figure out where is it going. If there's a joint owner who's still alive, that person now owns it. If there was a designated beneficiary on it, it goes to that person. If it's in a trust, it's controlled by the trust agreement. And after running through those 3 steps, we get down here and figure out, okay, what do we still have at this point? And if you have a will, the will is going to control that. If you don't have a will, state law is going to say where that stuff goes. But that's where the will comes in. And as I mentioned earlier, a lot of wills end up doing nothing. A lot of wills are written by married couples, and the couple is set up here for each other. And so one person passes away, and the other person just keeps going because they either were a joint owner on everything or the first designated beneficiary. and the second person passes away, maybe everything gets down here. One of the biggest misconceptions we run into is everyone thinks, well, if I don't have a will, I don't have a plan, and if I do have a will, it's gonna supersede everything. And no, the will is the backup. So that's misconception number one. Misconception number two is people think, well, if I have a will and it says what everyone expected it to say, and no one's contesting it, and I don't have creditor issues or anything like that, no reason to get a court involved. And that's not how that works either. If what gets down to this box is worth more than $86,000 or includes real estate, that is when the Colorado State Legislature has said this is enough that we would like a court to supervise the process of making sure this gets to the right people. So that is probate. So a will does not avoid probate. A lot of people who come in after someone's died and they have the will and we tell them you got to do probate. And they're like, oh, the whole reason we did this was to avoid probate. No. The first thing the probate court does is determine whether you have a will, whether it was validly executed, who's in it, are those people being notified, and all that. And so that's kind of there's two groups involved in a probate process, and one is your heirs, that's your family. The other one is creditors. Again, with this amount of stuff, the Colorado legislature is like, look, we want to give people who are owed money by this person a chance to show up and say that. So even if we're like 99% sure that you have no debt whatsoever, we still got to go through this process to just make sure that anybody who thinks you owed them money at least has a chance to make that case. And they don't have to be right. I get asked, could anybody assert a creditor claim against my estate? Like, yeah, they could. Part of the personal representative's job is to check this and make sure like we're paying money to the right people. So I just mentioned the personal representative. That is somebody that you would nominate in your will. It's probably your most important decision in this whole thing is who would do this job. Sometimes this person's called the executor. I think the consensus among Colorado attorneys who do this kind of work is that avoiding probate, that the probate process is not so bad all the time that everybody must avoid it. So if you're hearing this and thinking, oh my God, my family would have to go through probates, it's not necessarily terrible. It's not fun. It is a court process. We're dealing with grief and money and taxes and things that most people try and avoid talking about, so it's not great, but somehow that's going to happen one way or another. In Colorado, this really used to be like a court case where people had to show up and have hearings and get orders and get approval to do things before they did it. And I think at some point somebody realized we are wasting a ton of time with a lot of families who don't have any disagreements. They're doing fine. We don't need to make them come into court. So in a lot of probates, what happens is this personal representative gets appointed by the court, and then their job is to notify these people. It's a very specific process that they use to do that. Then they prove to the court that they did it. And once they've done that, the court's attitude is, okay, you guys have to tell us if you're unhappy with how it's going. If we're not hearing any complaints from you, we're just going to assume this person's doing fine. And that person goes out there, they sell the house, they close the accounts, they pay the bills, they file the final taxes, and they close it up and distribute the money to whoever's going to get it. So a lot of cases, there really isn't any drama, and the court has very low level of involvement. So I wouldn't just tell everybody you must avoid probate. I start to tell people you probably should consider it if you have stepkids, for the reasons I mentioned earlier. You kind of got to control things out a couple steps in a lot of those cases. If you have property in other states, you got to open probate cases everywhere you own property. So if you have a vacation property in another state, we're going to have two probates going on, and that can get a little bit messy. And then number three is if you have somebody in your close orbit who would be a pain in the butt in a court case. Right? If you got anyone out there who's pretty confrontational, if you're cutting anyone out or leaving them less than they might expect, all those kinds of things are kind of reasons maybe to avoid probate, because this is a real easy, like I said, it's a pretty easy process to handle, but it's also a really easy process to derail if you are the kind of person who likes to derail things. So because it's a court case, it's already open, you don't have to do anything, you can file a handwritten objection in there, and it really throws sand in the gears. So if we're trying to prevent somebody from finding out what's going on or discourage them from contesting this whole thing, we probably want to avoid probate. So if you've thought this through here, these three ways, these three techniques up here are your ways to avoid court, if that is important to you. Probably the most common way we do it is with trust planning. And this is part of the next part of this conversation too. So I'm just going to explain trust real quick. A trust, people get a little bit, anxious about trust. They feel like they don't understand it. A trust, it can be very simple. The people think they're complicated, they're for wealthy people. Not necessarily. We've had very simple trusts that just say, shoot everything out to these people. We've had very complicated probates or wills that have all kinds of instructions in them. All we're trying to do here is just keep this out of the court process. So what a trust is an agreement between three people. Person number one is the person making the trust. So there's lots of different terms for this. I call it the trust maker in my documents just to keep that clear. The trust maker is the person, obviously, who's doing this planning. They own whatever they own. They have opinions about how they want it distributed, who they want to do things, under what circumstances. We take those opinions, we write them down in a trust agreement, which looks a lot like a will. You would have trouble telling the difference if you didn't see them every day. And then we take that trust agreement and take all your property and hand them over to person number two, who's the trustee. And the trustee's job is to read those instructions and follow them. So if you're saying something that they don't agree with, you want to give it to some charity they don't like, or you want to give it to some person they don't like, or give away some asset that they would have liked to keep for themselves, they don't get to do that. They are here to exercise your instructions, and they are doing that for the last group of people as the beneficiaries. Anybody entitled to receive stuff from the trust is a beneficiary. And so this person really is working for these people. We get people coming into our office saying, well, I'm the trustee, so I'm in charge. I'm like, yeah, you're in charge, but you can be sued by these people if you're not doing your job, right? So you actually are working for them. If you think about it a little bit, what this really is like a company for your own stuff. Like the trust maker is the founder of the company. They're setting it up, they're saying why it exists, what it does. Then they're handing over the power to person number two, who's the trustee. That's like the CEO. The CEO runs the company, signs the checks, makes sure things are getting done correctly, but it's not their stuff. The CEO is running it for these people, the beneficiaries. Really, these are like the shareholders. So you might have heard of situations where like CEOs are running companies and they're taking company money and spending it on like their own vacations or living very lavish lifestyles and pulling it right out of the company's accounts. They are stealing from the company. They go to jail for that, right? I don't think I've really heard of a trustee going to jail, but you certainly can get sued for any improper use of funds. The challenge here is that a lot of times this person is in this group of people. So the trustee is also one of the beneficiaries. So people ask me all the time, can people be in multiple groups? There are lots of kinds of trusts out there. I'm going to talk about a specific one momentarily here. The most common type of trust is the revocable living trust. And the purpose of the revocable living trust is you're putting your assets in this trust to stop them from getting into this box and triggering this process. So like for me, rather than Dan owning the house and the investment account and whatever else I have, the Dan Trust owns that stuff. And the thing about that is, like right now, in that trust, I'm in, it'd be you, but in my trust, like I'm in all three of these positions. So I told myself what to do with my assets for myself. That might seem a little bit ridiculous, but the thing that unlocks is, in my trust, again, the most important instruction probably in the whole thing is, who gets to step into this trustee role? If you cannot do that job yourself. And again, that could be an incapacity event. It does not need to be death. And they're in there that day. They're not waiting for any court to authorize anything because on paper, I don't own anything. I'm just holding it as my own trustee. And somebody else can be the trustee. Just like I said, this is the CEO, The example I always use is Apple, right? So Steve Jobs was running Apple. He got sick. Tim Cook stepped in. He started running Apple. We didn't have to retitle everything from Steve Jobs to Tim Cook. It wasn't Steve Jobs' stuff. He was just running Apple. And then he returned for a while. And then he died. And so, he could step in and out of that position without any process at all, just because it's all not technically owned by me. And no matter what condition you're in, your trust is always alive and well. So that's what trust planning, that's the purpose of that, is to just make it real easy for someone else to step in or out and help you under whatever conditions you say. Obviously, if you pass away, this person's stepping in. But like I said earlier, what if you're traveling? What if you're hospitalized unexpectedly? What if you have dementia? Those kinds of things. What circumstances do you want to say where this person can step in?
That's where the executor comes in, right?
Yeah, this is a form of, so a trustee is an executor, a personal representative is an executor. They are executing the instructions. It's just, are they doing it outside of court or inside of court? Yeah. Whatever you do, whether you go through a trust or a probate process, you get out here, especially the kids section, you have to decide how you're going to leave stuff to your kids. And there's this range of possibilities for how you do that. One end of the range is to just say outright. Just once you're done with the bill paying, there's no more people asking for money, the tax hasn't been filed, we have found everything, we are ready to shoot it out to whoever you said. Just transfer those assets to them, they put those checks in their bank account, or they take over the real estate, it is now theirs, they do with it whatever they want to do. They don't have to ask anyone, they don't have to explain themselves, it is their stuff. The other end of the spectrum is to say, I'm going to give it to you, but I'm actually going to keep a third party in charge of it. There's still going to be a trustee. You're in position 3 still, but there's still someone else in position 2. I'm going to tell them when I actually want them to give you the money. And if you want the money, you got to ask them, and they're going to ask you why you want it. And if the reason you want it doesn't line up with what I said was okay, they're going to say no. We always do this with little kids, of course. You can't give a bunch of money to a 6-year-old. Obviously, it can be pretty popular when we have situations where somebody's got like a substance abuse history or financial mismanagement history, struggling with money and all that kind of stuff. But there actually is a benefit to being down here even if you don't have those kinds of issues. So people ask me all the time, if I set up this kind of trust, this revocable living trust over here, am I protected if I get sued? And I tell people, thank God the answer is no, because if we were all able to hide our money that easily, we'd be living in a completely lawless society where no one could pay anyone anything, and we'd just be running around committing torts and punching people who made us mad or whatever else, because we just couldn't be sued. But, because you created this. I just said, you're in charge of all this. Like, you can revoke it, right? So from a court's perspective, it's like, that's still your money. You just did it to avoid this process, which is fine, but you can't hit someone with your car while you're texting and you're drunk and not pay them because you put your money in a trust. But if somebody else puts money in a trust that was never yours, that you don't run, that you can't just change whenever you want, and you have to ask somebody else for, you really can tell them, like, yes, there is a pile of money over there for me. I'm not in control of it. I know I just lost a lawsuit to you. I know I owe you a lot of money. It's sitting over there. I don't control it. Go talk to them. They're going to say no. And that actually is going to work. So this down here, there's some hassle involved with this. Obviously, you don't just get your money whenever you want. There can be some cost involved. It can take some administrative cost to run it. It might have its own tax return and stuff like that. It is extremely protected. Not just from their own bad ideas, but from other people too. So my own parents' trust that I drafted has money coming to me in trust because I'm in a profession that gets sued a lot. So I would be okay with having some money off the radar, even if it means I have to go through somebody else to get to it. That person is my wife. She'll probably say yes if I ask her for money. This down here is no hassle at all. No protection. Obviously, it's just money in a bank account. So I'm not telling you to put your kids down here necessarily. I'm just telling you to ponder. Like, sometimes I tell people, go ask them. If they're old enough, if they're adults and you have good relationship over there, maybe go ask them if they would want to have money that's protected. It's a line here because there are some other things. You can make people co-trustees with each other so that they might have some role in it but still can't get money out. You can even say, look, I'm going to leave money for you. It's going to be in a trust. I'm going to tell you when you're allowed to get it. You're going to be the trustee. You're going to be the sole trustee. So you'll be in positions 2 and 3. So the good news is you will not have to ask anyone for the money because you're going to be the trustee. The bad news is, like, if this gets tested in court, I'm not real sure it's going to hold up. If the judge really doesn't like you and they're looking at this thinking, yeah, it's in a trust, you're the trustee and you're sitting in my court, so I'm going to order you to pull the money out of that trust and pay this person that you injured. they will probably win that. Down here, it's a heck of a lot harder because the trustee probably isn't there. It is probably not under the court's jurisdiction. So the point of this drawing is, as you're moving this way on this, you are increasing the amount of control you have, or I'm sorry, the control that your kids have over whatever they're receiving or whoever you're giving this money to. They are losing protection as a result. So you cannot have perfect control over assets and also have them protected even if you put them into a trust. So that's kind of the main takeaway from that. I've been talking about kids here, but actually the spouse is kind of like spouses are on the spectrum with each other too. So you might hear that and be thinking, of course, like it's our stuff together. Of course the survivor between the two of us should just continue to be doing whatever they want. Not necessarily. So my wife and I are the only people we've ever been married to. All our kids are together. Our plans are identical. We actually have two separate trusts. There's a Dan trust and there's a Tien trust. And what happens there is, like, my trust owns half our house, her trust owns half our house. We are both trustees of both trusts. We're both in all three of these positions in both trusts. So if I pass away unexpectedly soon, she's the trustee of both trusts that own the two halves of that house. She can sell the house. She can refinance the house. She can stay in the house as long as she wants. If she does decide to sell the house, what's going to happen is the title company is going to give her two checks. And one's going to be made out to my trust, and one's going to be made out to her. And she will have to take that check that's made out to my trust and put it in a bank account that is titled to my trust. She will be the signer on that bank account. Those funds are for her. The trust says the funds, you are the primary beneficiary of this trust. You can use those funds. What is the point of all this? If either of us die unexpectedly soon, the survivor almost definitely will get remarried. And so, again, even if that happens, that person will continue to be able to use those funds. They just can't combine them with that new spouse. And so ultimately, when this second person has passed away, the first person's wishes will be honored. The kids, you might think, well, your kids are her kids and her kids are your kids. Like, why would you disinherit your own kids? People accidentally do it all the time by getting married. I said earlier, you have to leave money to a spouse. So people get married, they're not, they divorce or they have their spouse pass away or whatever. They get a new spouse. They're not really thinking about this. But if you get a new spouse, your estate plan has to leave stuff to that spouse unless you thought to get a prenup, and even those can be pierced. We get a lot of kids in our office saying, yeah, our mom has passed away and our stepdad's not really talking to us anymore. It's like, yeah, it's his stuff now. So that comes up a lot. So if you, again, the blended family situation, which is so common, so especially, baby boomers might be probably on your later marriage, this issue is there a lot. So that's something for you to think about. So I mentioned earlier I was going to talk about a particular kind of trust, the most common asset protection question I get. So you might hear the term asset protection and be thinking I'm talking about offshore trusts and really wealthy and famous people who are trying to hide assets, or maybe African warlords who are trying to put money in some sort of secret account somewhere. You might be surprised to hear that South Dakota has become like the most popular place to hide money for people who are like international warlords because their privacy laws are so strong now. There was some effort to get rid of that. It's kind of been put on ice at the moment. But at any rate, that is not the most common reason I get asset protection questions. The most common asset protection question I get is from people who are getting to the point in their lives where they're worried that medical care is going to eat up their entire estate, right? And particularly long-term care. So I mentioned earlier, like, you can't put money into a revocable trust and consider that to be not your money anymore. It will not trigger a probate process if it's out there, but other than that, it is available to creditors, your creditors, it is available to the IRS, it's available to the court system, and Medicaid too. That is your deep backup. So if you cannot afford long-term care, and I gave, there is a handout, if you didn't pick it up earlier, one of the handouts you've got in front of you is about Medicaid planning. So I looked it up just before I came here. Right now in the Denver area, I think the average is somewhere between about $10,000 and $14,000 a month to do long-term care. That's a lot. And I think most people who go into long-term care need an average of about 2.5 years. So the math is on that form there. So that's about $360,000 to do long-term, to cover long-term care. It is not covered by Medicare. Medicare has, I think a 90-day limit for how long they'll cover things. Beyond that, you are on your own. So if you don't have long-term care insurance and haven't thought about anything otherwise, you're going to be self-funding that. So obviously a lot of people worry, gosh, that's going to eat up pretty much my entire estate if I don't figure out something otherwise. And Medicaid, so Medicaid's kind of confusing because it's got two different programs. One is like the health insurance. If you don't have sufficient income, you get Medicaid health insurance now. The Big Beautiful Act, now it's a Big Beautiful Act, I think is changing that. So you're hearing about, Medicaid is going to be covering less people now. So that is going away a little bit. But there is still insurance out there that is provided by Medicaid. And it's just like you go to the doctor, you pull out that Medicaid card, they're covering your appointments and stuff like that. That is an income-based issue. So you can have a ton of assets. And if you don't have income for whatever reason, Medicaid will provide you with insurance coverage. And then there's long-term care. Long-term care is about assets. So if you go to Medicaid and say, I really cannot afford this long-term care, can you cover that? They will say yes, but you got to get rid of all your own stuff first. You got to spend down to $2,000. So you pretty much got to get rid of everything to get Medicaid coverage. There are some programs in place where if one spouse is looking at long-term care and there's a healthy spouse, that the healthy spouse does get to keep a number of assets. They get to stay in the house, they get to keep a car, they get to have some income and all that kind of stuff. But for people who do not have a spouse, the spend down really is this $2,000 thing. So people are trying to figure out, how do I get assets out of my name so that I can qualify for Medicaid? And so one thing that people do, and again, I hesitate to bring it up because it's not the greatest idea. They start gifting things to kids. Like maybe I'll just put my kids, I'll just transfer the house to my kids now, and then I won't have that, my biggest asset will be gone, and I can qualify for Medicaid sooner. Again, you could actually cost yourself more in taxes. I've had a number of clients who show up with deeds that have a 5-figure purchase price on them, and they're like in Greenwood Village, right? So like, wow, this probably has like, $900,000 of gain built up into it. If you give it away to avoid losing, spending money on long-term care, you're going to end up costing yourself more in capital gains tax. So you just want to be very careful about doing that. There are, like I mentioned, long-term care insurance. There are a couple other things that I mentioned in there. If you're a veteran, you might have some veterans benefits available to you. There is something called a Medicaid compliant annuity that can be helpful in some circumstances. It gives you a flow of income and gets assets out of your name. But the most common thing we do when we're doing this is a Medicaid Asset Protection Trust. And that is a trust that is specifically designed to get assets out of your name for the purpose of getting down to this $2,000 number. And it's the same structure. All trusts are the same structure. We got these 3 people involved. The thing that sets a Medicaid Asset Protection Trust apart from the revocable trust I was discussing earlier that is so common is it's not revocable. If it was revocable, Medicaid, from Medicaid's perspective, like if it's revocable, you just change it. Like if you turn out not to need the care, you're just going to take all your stuff back, and everyone's going to do this, and we're going to end up paying for everyone who needs it, and anybody who doesn't need it, they're just going to take their stuff back. So we can't have that. So you've got to make a commitment. There's got to be an irrevocable trust. And you probably cannot be in all 3 positions, and the position you're probably going to give up is trustee. So you got to figure out, okay, who's going to be my trustee? Now the trick here is, you might have heard of what's called the 5-year look-back period. And again, from Medicaid's perspective, they can't have people finding out that they've got a diagnosis of dementia or Alzheimer's or something that's likely to put them into long-term care and suddenly start getting rid of all their assets. So they look back 5 years at all the transactions you've done to see, are any of those transactions for less than fair market value? And whatever you've done that caused an asset to leave your estate for less than fair market value, they're going to take the amount of money you should have gotten if you had gotten rid of it for fair market value, and they're going to disqualify you for as much time as that would have covered. So, you try and get smart about it and say, well, I didn't give away my house to my kids. sold it to them for $100,000 and it's like a $500,000 house. Okay, well, you gave them a gift of $400,000 then. How much, assuming it's $10,000 a month, how much would you have gotten? So 40 months. So you're going to not be able to qualify for Medicaid for over 3 years while we wait for that to play out. So either go get that house back from your kid and sell it the right way, or come up with some other solution, because we're not covering this. This applies to that trust too. So you have to, the challenge with Medicaid trust planning, and we've got a little self-assessment questionnaire there for you to ask, because it's not right for everyone. If you don't have enough money to protect, it's not worth doing. If you have enough money to self-insure, maybe you do that instead. There's kind of a sweet spot for how many assets you should have. And then your health level has to be good enough where you feel like, you know what, I probably can go 5 years without having this issue. But if you've got a strong family history of dementia or Alzheimer's or things like that, and you're feeling like, yeah, I could probably go, I have no issues now, you got to do it. You got to make hay while the sun is shining, right? So I compare, like we get people again coming in saying, well, she's got a dementia diagnosis, she's living with us, she's pretty reliant on us. Can we start doing this? It's like, are you going to be able to go 5 years? This is like trying to buy home insurance while the kitchen's on fire. You can't wait that long. So that is a challenge. You have to have enough assets to make it worthwhile. You have to have enough assets where you can put some stuff, usually with asset protection planning, whether it's this or whatever else it is. We're not putting every single thing into that trust. You can't make yourself insolvent. There's got to be like, a way to support yourself with the assets you don't put in the trust for those 5 years while you're waiting for this to kick in. But then if you really make it the 5 years, like those assets are off the table. So it can be very effective, and it can save you a lot of money. I mean, everybody's, the two assets we see the most that are the biggest assets in most people's portfolios are either their house or their retirement accounts. And you can protect those things. And I did, we charge quite a bit more to set up Medicaid trust because it's very tricky. The Medicaid book is like, a phone book, and it changes constantly. So there's a lot of stuff to know. And it is irrevocable, so we've got to be a lot more careful with revocable trusts. I mean, we're always trying to be careful with our drafting, but a revocable trust, if something changes, it's like, okay, just go change it. An irrevocable trust, you can't really do that. So you got to be very careful on the front end to make sure everything's right. So, they cost quite a bit. Like when usually people tell you, it's like $15,000 to set up that kind of trust. And people hear, like, oh my God. But if you do the math, and you figure, well, if I save my house, it's like hundreds of thousands of dollars potentially. So, like I said, I gave you a self-assessment. If you didn't get it, there might be a few more copies there on the back. I'm happy to, if I didn't bring enough, I'm happy to email them to anybody. But that is something to consider. Like I say, it is our most common question about asset protection is how do we get stuff out of our name and make sure we don't lose everything to medical care. People feel very strongly about that in a lot of cases. Just to quickly wrap up, and then I'll take the questions. So for us, every estate plan has at least 5 documents. Everybody does get a will. Even if you do set up a trust, you still have a will. If you have a trust, the will just says take anything that was not in the trust and put it in the trust. The goal with trust planning is to put as much as we can there. Maybe we designate it as the beneficiaries. We're just trying to make sure that whatever's not in that trust is below this $86,000 threshold. But you can see all the arrows are pointed at the trust. So the benefit there is going forward, if you have changes to make, again, if we're using designated beneficiaries and jointly titling stuff and all that kind of stuff, anytime you change anything, you got to think back, okay, who's on what and what designated beneficiary. If you have a trust, you just go to the trust agreement and change the instructions there. If you don't have a trust, and again, we do not do trust for everybody. Not everyone's worried about avoiding probate. You still have a will. The will in that circumstance has all the instructions. Document number 2, we always do the financial power of attorney. Again, that's for the incapacity events. As I mentioned earlier, a trust, one of its other biggest benefits is you can say the circumstances in which the trustee can step in, and incapacity is going to be one of those circumstances. But even with a trust, stuff can come up with your taxes, your insurance, utility service providers. If you have any separate assets from each other, like I can't necessarily just go in and do what I want with my wife's retirement account. If she has her own bank account, I can't get access to it unless I have written permission to do it. If your house is jointly titled with each other, you can't do any transactions with that house unless you're both there. So even spouses run into barriers, actually. So financial power of attorney is very important to have. And like I said, it probably should have been executed within about the last 3 years at the most. Number 3 is medical power of attorney. Who's making medical decisions for you if you cannot? And that's the entire gamut. That could be life or death, like very difficult, like this person's just had this pretty significant event. How much intervention do you want us to try here? It could just be you're getting a tooth pulled, and they need to pull another tooth that they didn't think was a problem, and they need somebody to authorize that. So it can be very minor, very temporary, not life-threatening, but somebody needs to sign something and you're under anesthesia. Who's that person? And again, you might think my spouse could do it. I don't know about that. I don't rely on that. Last time my wife gave birth, they sent me home during that check-in process to get her medical power of attorney. Like, we're not taking instructions from you unless you show us that document. And like, I couldn't call my wife's primary care physician and get her records without her permission to do so. And then everybody asked me, is this the person who decides whether or not to unplug me? That is a question you can leave up to them, but that really is the living will. Living will is very specifically focused on if you're in a situation where you're receiving treatment, 2 doctors have evaluated you and determined, look, you're dying. We are stopping that from happening, but really that's all we're doing. We're not going to be able to make you better. You're going to die if we stop this treatment fairly quickly. Do you want us to keep doing this or not? This often gets confused. When I bring this up, people often are like, oh, is that the DNR? DNR is a do not resuscitate. The DNR is the other way around. The DNR is you are found unresponsive. Should they start? A living will is they've already started. Should they stop? So usually DNRs are for people who are very advanced in age and kind of their quality of life is diminishing and they're feeling like they're in a lot of pain and they would not want to be having CPR performed on them to come back to a fairly painful existence, frankly. A living will is like 25-year-olds should have that document because that could happen to anybody at any time. And then the last document we do for everybody, if you don't already have it, is memorial instructions. Do you have any thoughts on cremation or burial? Do you have any thoughts on a funeral memorial service? Everyone gives that pretty short shrift. This is the one I hear the most often. Every week somebody tells me I'm going to be dead. I don't care. My family will figure it out. Everyone assumes that there's going to be fighting, it's going to be up here, and it's going to be about money, which is probably usually the case. But when we see fights down here about end-of-life decisions or how to memorialize somebody, it's real bad because there really isn't any way to compromise. It's not like you're going to say, well, okay, I'll let you bury mom, but you got to give me $5,000. Like, it's like, no, she didn't want to be buried, right? So we have some crazy stories about physical altercations in funeral homes. Yeah, so everybody for us gets these 5, like you should probably have those 5. And then for us, the 2 questions beyond that are, do you care about avoiding probate? And if so, do you need to use a trust to do it? Like I say, you got 2 other options for avoiding probate up there. The trust is usually the actually most elegant. So if we're doing that, we have a trust agreement on top of all this, and we're titling stuff to that trust. The other question is, do you need this ongoing money management component down here? Do we need to tie up stuff in trust for your beneficiaries for any reason? Or are we just giving it to them outright? These are 2 independent questions. You can have a living trust that just says, look, once you're done with the administration process, just shoot it to them outright. Or you can say, you know what, I don't care about avoiding probate, but ultimately when that process is done, my son needs to have his money held in trust for him. He's receiving disability benefits. If I give him money directly, he's going to lose those benefits. That's another common situation where people shouldn't necessarily give inheritances outright to their kids. And then, like I said, a Medicaid trust is certainly not a conversation we're having with everybody, but might have it with at least some people in this room. So that is the presentation. So like I said, trying to get you out in an hour, but I'm happy to take questions before I do. Yeah?
Repeat the questions for the mic.
Yes, I will repeat the questions because I got a mic on. Yes?
If an estate has to go to probate and it's more than $76,000, what do you pay taxes on and how long does probate last?
Okay, so the question was, if it has to go through probate, when did the taxes get paid, and how long does the probate last?
Yeah, or how much will you be taxed on?
Yeah. So whether it goes to probate or not really doesn't affect the taxes. If you have money in a trust, there are ways to get, again, there's other kinds of trusts out there besides the Medicaid trust and besides the revocable trust that are designed to get assets out of your estate so that they don't get taxed. When people talk to me about taxes, I think they usually have in their mind the estate tax. Seems like the tax you'd be worried about when you die. Right now, so again, referring to the Big Beautiful Act, I mean, even before that, right now, individuals are allowed to give away almost $14 million before you have an estate tax. And married couples are allowed to combine that and give away $28 million. The Big Beautiful Act is increasing that to $30 million for married couples. So I don't have a ton of clients who actually have an estate tax problem anymore. So really, there is not necessarily tax. But you've got two other taxes you got to worry about. One is income tax, and the other is capital gains tax. I've mentioned capital gains tax a lot. That is the one people, again, they do stuff to try and circumvent probate, and they're taking assets out of their name and stuff like that, and they are accidentally losing the benefit of the capital gains step up. That is your most likely problem. And then income tax is usually there's an income tax return due for a person who passed away if they're paying income taxes during their lifetime. And then if their estate has anything in it that is continuing to earn income, the estate can have an income tax. And usually when we try and solve a problem with one of these taxes, we create more problems for the other two. And so you just got to think through that a little bit. But there's not necessarily an estate tax due. You might, I mean, you've got a lot of money. You've got up to $14 million to give away over the course of your lifetime and at death before the people who receive that stuff. And the people who receive it don't pay income tax on it. The one exception is retirement accounts are holding money that has not been taxed yet. As you receive money, if you're a person who's receiving money from somebody who passed away through a retirement account, you are going to declare that as income and pay tax on that.
Well, what I'm referring to, if it has to go to probate and you only have a will,
Yeah.
how much money has to be in probate?
I mean, so the question was how much, if you're going through probate and you have a will, how much is going through probate? Yeah. Anything that isn't up here, it's usually a mix. So a lot of people, again, have retirement accounts that have beneficiaries on them, and that is their first or second biggest asset. That money might be going out, and then they have a house down here. We've had situations where all the money is going out through one of these methods, and the only thing going through probate is the house. So you just got to go through your assets and think through this. Like, is there anyone else on there? Have I designated a beneficiary? Is it in a trust? If not, it's going through this. But you can have a lot of stuff. I had one probate where the only thing going through here was half a house. The person ended like that was the only thing they had not accounted for.
But I have two houses.
Okay.
So what is a beneficiary deed? Is it necessary to get that, you think?
So she's asking, so if you have a second house, a beneficiary deed, it just depends on whether you care about avoiding this process. Like I said, I don't necessarily tell you must care about this.
Well, I don't, except I want to know how much tax they're going to have to pay.
So she's asked about tax. I mean, that's not going to affect that.
It can be up to 14 million.
Yeah, 14 million. Over the course, so you might be familiar with like gift tax returns. Right now, you can give away $19,000 per year to people without telling the IRS about it. And people get confused about this. They think if I can only give away $19,000. I can't give away more than that. You can give away as much as you want. If it's more than $19,000 to any individual, then you have to tell the IRS on a gift tax return. And you don't owe any tax. What happens is when you die, the IRS is going to take all the gift tax returns you filed, add them back into the estate, and if at that point your estate is worth more than the 14 or 15 million bucks, then your estate's going to owe a tax on everything above that.
I have a question.
Yeah.
When a home is in a trust, does it benefit from the capital gains tax exemption of $250,000 to $500,000 when the trust sells it?
Yeah. So he's asking whether you still get the exemption, the capital gains tax exemption, when you sell your house, if it's in a trust. If it's a revocable trust, so you might be aware, if you have a trust or if you have a house and you're single, you can sell it. You get $250,000 tax-free, and then anything above that, the capital gains tax is going to kick in. That gets people trapped actually when they are in a house again that they had with a spouse. The spouse passes away. When you're married, you get $500,000. But if the spouse passes away and you stay in that house for more than a year, like you're going to lose, it's going to get cut to $250,000 actually. So we get people who's lost a spouse, they stayed in the house, they only get the $250,000. A revocable trust, yes, you get the exemption still of the capital gains tax. If you start putting stuff into irrevocable trusts, again, what I mentioned earlier, so people are putting houses into irrevocable trusts to get it out of their estate, usually to avoid estate tax. Now they're causing themselves issues for capital gains tax purposes. So you just got to run the numbers there and figure out, am I going to have more problems with capital gains tax or estate tax? And if you have an estate tax problem, God bless you, you're doing really well, right? This is a lot of money you can give away. Yeah.
Is it 1 year or 2 years?
Yeah, I think it's 2 years.
Yeah. So is it 1 year or 2 years that you have to be out of the house before you lose that? Yes, 2 years. Yeah.
The spouse has to be paid.
Yeah.
The remaining spouse.
Correct. Yeah.
The other question is, what consists of your law firm?
Oh.
I read a little bit of this, and it sounds like you have family in there.
Yeah, so my wife, who I mentioned earlier, is one of my paralegals. I have another attorney. He asked what my how big my law firm is. So yeah, I have a couple paralegals. One focuses on estate administration, actually doing the administering the plans for people who have passed away, and we got one who focuses on the planning side, and that one is my wife. And then we've got several different administrative roles. It's me and one other attorney. I'm the only owner, so there's about 9 people involved in the operation. Yeah. Yes. Yes. Yeah. Yeah.
I'm asking about the beneficiary deed.
Yeah.
Single person, no spouse, 1 child. Does that, if you do a beneficiary deed, can you avoid everything else?
Yeah. So the question is, does a beneficiary deed avoid everything else? Yeah. It's like I say, it's up here. It's above this line. And it's as easy as if you put the beneficiary deed, again, it's a very specific type of deed. It's got to have some a couple pieces of very specific language on there. I usually tell people, like, we see a lot of people draft and file their own deeds, and boy, when you screw that up, it's like not good. It's really hard to undo. It's publicly recorded. We've seen people, again, try and save themselves a couple $100 for the title company or attorney to do this, and because it looks really deceptively simple. If you make a mistake, it's not good. But other than that, like I said, that's kind of the ideal situation. If I'm just leaving this stuff to one adult, you pass away, that adult gets your death certificate. They take that to the clerk and recorder's office. They record it, and the house is now that person's. There's no probate process.
So do you have to keep renewing that also?
No.
When you said to renew a
No.
will every once in a while?
She's asking if you need to renew that. No, if it's on the record, you can revoke it, but you have to revoke it to undo it. So like I said, it doesn't help in incapacity events, whereas trusts do. And then the other thing, I just had something cross my mind. Oh yeah, if you move, you got to remember to do it again. That's the issue with designated beneficiaries is every time you change banks or do something new, you got to remember to do the designated beneficiary again. One of the warnings you have to put on a beneficiary deed is this is going to disqualify me from Medicaid coverage for long-term care. Because one of the things Medicaid does is they say, look, if you use long-term care and you hold on to your house, like you can get Medicaid coverage that gives you in-home care, but they're going to lien that house when you pass away. And if you use the beneficiary deed, like, wait a minute, where'd it go? It's not under, it didn't go through probate. They want to make sure it goes through probate so they can make that creditor claim. So if you have a beneficiary deed, if it comes up, you can revoke it. But it is it is required to be on the deed. Warning, this is going to disqualify you from Medicaid. Yeah.
Is there a standard amount that an executor would be paid to handle the closing of the estate?
Yeah, so he asked, is there a standard amount an executor is going to be paid to close the estate? Yes, they are entitled to compensation. And I usually tell people who come in who are going to be doing that job, just keep a track of your hours. It's a lot of times it's family members, and a lot of times they assume I'm not going to do it. and then sometimes it drags on longer, or some sibling is being a bigger pain with them than they thought they were going to be. It's like, you know what, I am going to charge. Now that you're being such a pain, I am going to charge for this. And it's like, okay, well, we're a year and a half into this, and you have no idea how much time you spent. I don't know how you're going to charge. So usually it is time-based. It is reasonable. It is a reasonable amount of money. And what is reasonable? Hard to say. You have to tell the beneficiaries, like at the end of the probate process, you have to provide them an accounting showing all the money that went in and out of the estate while you were doing this. And one of the line items is going to be your charge. And if your charge is ridiculous, they might ask a court to take a look at that. So that's kind of the constraint. Every once in a while we have somebody put in their trust or will. They want to say, well, I know this person won't take it unless I make them. So I'm going to make them take it. And I'm going to say they get $100,000. Now, you can do that. The problem is, it's like, this might be real easy, and $100,000 might be way out of hand, or it might be real hard. It's like, oof, that was actually not enough. So reasonable is just like, again, keep a time log, and I'd say for a person who doesn't do this professionally, probably $50 an hour, give or take 25 is reasonable with documentation. I've got someone who's saying he wants to charge $50 an hour for 80 hours. I'm like, that's okay. That sounds reasonable to me. What's your documentation level? So that's where people fall down on this. They really don't document what they're doing. So, yeah. Yeah.
The 5 points up there for the estate planning, to
Yeah.
get that in place, how many hours, legal hours to set that up?
So we typically do flat fee stuff, but not hourly. And we can tell you, so we, if you're asking like what our fee is, like we would want to learn more about your assets and more about your family just to make sure we understand what we're dealing with. Sometimes we have people come in and say, I just need a simple will, and you find out it's like, I'm a doctor and I'm on my 3rd wife and we have, property in Hawaii. I don't think a simple will is going to do it here. Or sometimes people come in and say, I need a trust, and I'm like, you don't really have anything to put in a trust, frankly. So it goes both directions. But yeah, it can be a couple $1,000 up to, $8,000 if you're doing like small businesses in there and that kind of stuff. But we do give you a flat fee. So I was going to tell you, so normally when we meet with people, we do charge for that meeting. As an attendee of the seminar, if you want, I would be happy to have a conversation with you for free. And I usually don't do that. And just hear what your situation is and tell you specifically what we would charge for it. So I think you have our contact information and can call us and I'll tell you a flat fee. But yeah, usually at the lowest end, we're still charging a couple thousand. I said that the deeds are deceptively simple looking. Wills can be too. I mean, a will can be any, people ask me, well, do I need to have, some level of formality to a will? Like, you can write a will on a cocktail napkin. You don't need an attorney to do it. If it's in your handwriting and it's signed and dated and it says, this is what I want to have happen when I pass away, that's going to be your will. I read a story in law school or a case in law school where the guy was in the hospital bed and wrote some stuff on the wall, and they had to cut that wall out and take it into the court. That was his will. Another one, where'd my pen go? In the footnotes, this woman brought a cocktail napkin in that had this drawing on it, an arrow and a dot. And she said, my boyfriend and I were having cocktails at a restaurant one night. He pulled out this cocktail napkin. I'm the dot, and this arrow is representing that he wanted everything to go to me. So this is his will. So it's not dated and signed. It's got to be dated and signed. But we get a lot of people who do obviously their own drafting, and it's just a lot of ambiguous stuff and just not really matched up with, people kind of think the will is just for like their kids. The IRS is involved in this. The primary people really are the banks. Every bank has a compliance department, and those people are looking for something to do. If you bring documents in, they are going to want to read them and pick them apart, and just if it doesn't have what they're looking for, I mean, even with us, we get several things sent back all the time saying, well, we needed to say this or whatever else. It's like, I know you need to do this to justify what you're getting paid. This is annoying. Just having some level of oversight is pretty important. But yeah, like I said, if you tell my staff that you were here at this seminar, we can schedule a phone call for free, and I will tell you the fee. Yeah.
And Do you normally want to do all 5 of those documents?
Yeah, like I said, this 5, like I call these 5 the core plan. Like I say, everybody gets those 5. Every once in a while, there really is a situation where there's just not a need for a will. They just don't own any property at all. They're living with their kid or whatever, like no real estate at all. They just want to make sure their kids can do stuff for them while they're living. But that's pretty rare. Usually these 5 are kind of the baseline.
But
And
you
then,
have some of them already.
yeah, it depends on how well, yeah, so that comes up to if you've done it recently.
Do them, I suppose, or whatever.
Uh-huh.
Or we may want you to.
Yeah, yeah, and if it's, like I say, you know, this changes more often than you'd think. I mean, I opened my firm in 2013, so 12 years in the overall scheme of things, that's not really that long. And God, the number of changes for retirement accounts especially has been crazy. And like I say, the tax laws they keep changing constantly. So it's more often than you'd think, even if things aren't changing in your family. And the number of people who come in and they tell me, I did this 4 years ago. They're always off by a factor of 2. It's like, okay, you just said 4, it's 8. People do not correctly estimate how much time has passed when they're doing this stuff. So, but I'm happy to, yes. It's not, if you don't need some of these for some reason, we do bits and pieces sometimes.
Oh, one other thing.
Yeah.
If a couple comes in
Mhm.
and you say basically a flat fee for 2,000.
Yeah.
But if you each have a will, does that make it 4,000?
No. So yeah, we have married couple planning and single person planning, and they are different.
Okay.
Yeah.
So
So
that's
usually with married couples, yes, it is one fee, and
one
yeah,
fee.
yeah,
Okay.
yeah.
Well, thank you very much.
Okay.
I'd like to add some little free advice and things I'm about to say you may have read about in my column, since I think everyone here is here because they read my column. This reminds me of something I've written about, which is that under the Federal Electronic Signature Act, which is like 20 years old now, if you send an email and you say, I'm going to leave my house to you, and you then type your name, Jim Smith or James Smith or whatever, that is a contract, and that could be taken to court and said, he signed this because it's considered an electronic signature. He signed this email to me saying that he was going to leave me my house. That applies if you're selling your house or any other promises that you put in an email about, I'll sell my house to you for $5,000 because I love you. And then they type their name. Now, if they send it and they don't type their name at the end and it's just from Jim Smith, but it's not signed by typing Jim Smith, then that's not a contract. So just keep that in mind whenever you're sending emails. Or writing on napkins, because homes have been sold based on napkins where a person wrote something on a napkin and signed it. And that was a contract. So just keep that in mind. The second thing I want to mention is that, as many of you know, I sold my home. Here I am, a realtor who doesn't believe in his own product, you might say. But I sold my home. I'm 77. I'll be 78 next month. And 2.5 years ago, we decided we were sort of at the top of the market, and that may still be true. So we sold the house, walked away with $1 million in cash after paying the residual mortgage plus capital gains, and we invested that money. But we also have between us $5,000 in Social Security income each month. My point is this: we live in an apartment now. We have no responsibilities, and we have no big estate to liquidate. All of our money is in either an annuity or with an investment guy who's investing it in the stock market. My estate is going to be very simple, and so is my wife's. And we're going to not have to mow the lawn, blow out the sprinklers, or shovel the sidewalk or anything else. So we are really happy with that decision. And it turned out that we haven't even eaten into our $1 million except for this world cruise I went on last year and the future cruises I'm going on, because the Social Security, well, plus I'm still working, so that doesn't count. But if I weren't still working, I wouldn't even really need to be eating into that money thanks to Social Security. So that's something you might consider if you're burdened by having a home. The other advantage of being in an apartment, of course, is that you can lock and leave. we can go for a 2-month cruise and not worry about anything, the mail, snow, burglary. It's not going to happen in a secure apartment building. So just wanted to share that advice with you. And so I'm really pleased with that decision after listening to all this, because, yeah, I suppose I could have a trust, but it would be a pretty simple trust because everything's liquid in effect. So
I will say every problematic probate we have involves real estate. Real estate's the problem, because real estate's unique. That $1 million in that bank account, like, no one cares which dollars they get. Right? They do care about real estate. So I'm sure we've got a couple coming down the pike where I've got collectibles, like huge collectible items in there, and that might be a problem. But real estate is frequently, and the most common situation as a problem is there's a kid living in the house with the parents who was kind of helping take care of things, and they're expecting to stay there. And they have no legal right to do so.
So as I said, we videotaped this. It's going to be on my YouTube channel, and I'll publish the link in the next version of my column. So you can share that with people who couldn't make it here, or people who are in your family who need to know what you learned tonight. My YouTube channel is Jim Smith 145, so you don't really need to wait for it. But of course, you won't see this video for a day or two because I have to process it. Thank you all for coming. I really love meeting my readers. I've met a lot of them over the years. I don't know if you know this, but I've been writing that column for 20 years. And I'm not sure I'm going to write it for 22. But it's been a pleasure doing it, and a pleasure developing these friendships and this trust that I've built from doing that. And I just can't thank you enough for believing in me and simply reading what I have to say. So thank you. Thank you. So you're released.